Another finalist was Beware of the Fine Print, a New York Times series that looks at the fine print in consumer and employee contracts that seriously disadvantage those that sign those contracts, that forces them into arbitration, often loaded arbitration, and also prevents class action suits. And that particular series has led to legislation being introduced that will stop some of these practices. Representing the New York Times team is Jessica Silver-Greenberg, who is a reporter at the Times who covers banking and consumer finance. She was a Pulitzer Prize finalist for a series on debt collectors and a Loeb finalist in 2014 for a series on how the nation's largest banks prey on older Americans. Jessica.
Sorry. So our story started when my colleague Michael Corkery and I were working on a story about how military members whose homes and cars had been illegally seized by banks were finding when they went to try to do anything about it, when they went to sue under this key federal law, they were being blocked from court and sent to this system, which at the time we had no idea about. This thing called arbitration seemed harmless enough, seemed a little boring, in fact. You know, you say you want to do a series on arbitration and people literally kind of go to sleep in front of you. And so we started trying to look at what this private system was, what this alternative to court was. And at the beginning, it was extremely challenging just to figure out kind of what happened in arbitration, in part because the system is designed to be incredibly secretive. It's one of its advantages for the companies who bring cases there, is nothing that they do or that happens there ever makes it out to the public. So even if it's a case of wrongful death, which we found, you know, cases that went to arbitration over wrongful death, people dying in nursing homes over neglect, or actually someone who was murdered in a nursing home by her 98-year-old roommate, that even those cases don't make it out. And so Michael and I started looking around, trying to figure out what happened in arbitration. And by doing a lot of legal research to see who was trying to appeal decisions that had happened in arbitration, we started to get a glimpse of the nature of the cases that went there. And what we found initially was really shocking to us. There were things like NFL cheerleaders who were bringing labor cases against the NFL for unfair working conditions, whose case was in arbitration going to be heard by the commissioner of the NFL. We heard of plaintiffs who brought cases who lost and were told to pay hundreds of thousands of dollars in the other side's legal fees for things like private plane travel and hotels. But then there was a story that developed simultaneously. So we wanted to assess, it wasn't enough to just do an anecdotal look at arbitration and these horror stories. We wanted to see how people fared in comparison to court. And so because there are not really public arbitration records, we went to all the arbitration providers and asked them for the data, which of course they wouldn't give us. So that took a lot of calls, and we would be shuttled from, you know, someone would be like, we'll get that to you right away, and then I would get a telephone number that wasn't their legal counsel at all. It was one person sent me to I think it was a fishing company, to get the data. But we eventually got what amounted to about 25,000 arbitration records. We had no idea what to do with them at that point. And that's when my other colleague, Rob Gebeloff, stepped in and started analyzing how many people went to arbitration against various companies. And that's when when a second story started developing. So it wasn't just about what happened in arbitration, it was also about the nature of certain claims weren't going to arbitration at all. So we started looking, say, at Sprint, a company that has 65 million customers. And in 4 years, only 4 people went to arbitration against Sprint. So you have to imagine, I mean, we thought there's got to be more people that have had problems with Sprint than just 4 people. So that's when we started realizing that the arbitration, while it was a system that was very slanted against plaintiffs, was almost beside the point. Arbitration clauses, which are the fine print that all of you, if you pulled out your credit cards right now, would have a clause that says the company can elect to take you to arbitration instead of court, which, so you've signed away without even realizing it your constitutional right to a civil trial. But in that clause, there is an even more powerful thing. It's a vehicle. The clause says you cannot file a class action lawsuit. And for any of you who've gotten in the mail that coupon that says you've been enrolled in a class action lawsuit, here you have $20 for that, because of your checking account or something like that, you might not realize what the real power of eliminating your ability to file a class action lawsuit is. But all the corporations that put those clauses in there do. And what they realized, what a team of corporate lawyers realized, was by banning class actions, you pretty much disable lawsuits in general. Because most people won't go to court over, certainly not over a $10 fee or, a predatory practice. They just will abandon their case altogether. So once you get rid of class actions, you pretty much disable all threats. So what we saw was, and that what we had to go about trying to figure out was how these businesses, how corporate America had basically written themselves out of the legal system altogether. And they had done it with these seemingly innocuous clauses that are in, as I said, everyone's wallet. So we basically had to go to law school to try to figure it out. I mean, my colleagues and I puzzled about it for days and weeks, because what we started to realize was, without really anyone noticing, this group of lawyers working for credit card companies had engineered one of what really we think amounted to one of the most kind of audacious coups in corporate America, which was they wrote themselves out of the legal system. And they did it in such a complex, legalistic way that anyone who had tried to figure out what they did had been dissuaded from kind of going into it at all, because it was, it was not drama on the high seas. The coup that they did, it didn't happen on a battlefield. It happened in a bunch of boardrooms, starting on Park Avenue and then in Washington, D.C. And so we then set about trying to get people to tell us on the record how they had done it, and how they basically, in trying to exempt themselves from the court system, gone all the way to the Supreme Court and gotten the blessing of the Supreme Court in 2011 and then again in 2013. And almost no one noticed. So we set about trying to do that. Yeah. Oh, yeah. That's it. Yeah.
Good.
I mean, there's a lot more, but...
Good. Jessica.
You can ask me questions.
Good. Jessica, thank you. Jessica.
So I think we had two kind of primary challenges. The first was, I mentioned briefly these two Supreme Court decisions. So there was one in 2011 and one in 2013. And both received almost no attention, in part because they were dense, legalistic decisions that basically said, they were premised on this idea that it was fine to ban class actions. It was fine to say you cannot go to court. You're waiving as, a condition of, say, going into a nursing home or signing a credit card or renting a car or taking out a student loan. You're waiving your right to file a class action, and that's fine because there's this other great system called arbitration, which is a perfectly fair alternative to going to court for people to resolve disputes from, any kinds of disputes, whether it's a small dollar dispute or something larger. And that had been largely untested. So this incredibly kind of important basis for these two decisions, no one had gone about seeing, well, is arbitration actually a fair alternative to court? And there are a couple of reasons why people didn't do that. One, there's no federal requirement that arbitration decisions be disclosed publicly. So no one had looked at kind of how many people were actually going to arbitration. That was the first thing. And so with my colleague Rob Gebeloff, we saw, so between 2010 and 2014, only about 500 people, 505 people, went to arbitration for disputes of $2,500 or less. So this was this whole notion that, you know, millions of people could fairly resolve their disputes through arbitration. We started to see that that was incorrect. But it was a huge challenge to even get to the point where we could quantify the number of people who were going to arbitration. So that was the first thing. So what our reporting showed was basically we ended up at this idea that, you know, corporations had killed the class action. But it wasn't enough to just stop there. The next huge challenge, I think, was trying to figure out the way that they did this. Because, as I said, this amounted to a huge power play. You know, you as a corporation can just get out of the legal system entirely. You can opt out. But how did you do this? And the reason that I think people hadn't figured this out was because it was a very technical process. So what had happened was about 10 years ago, maybe 20, state court judges, when they were getting cases where companies were saying you can't file a class action, they were saying, no, we're going to strike this clause because we're going to overturn this clause and allow you to go to court because this amounts to having a get-out-of-jail-free card. They actually said that. They said, look, Discover credit card company, if you ban people from going to form a class action, you are exempting yourself entirely, and so you're getting out of jail free. So we saw that state court judges were striking down these clauses, and then suddenly that changed. So the state court judges what happened was a case where a state court judge in California had struck down a clause, made it all the way to the Supreme Court. And the Supreme Court basically said to the state court judges, no, you're overstepping your authority. You have no right to strike down these clauses. We're going to uphold them. But we set out to try to figure out how that happened. And in order to do that, we really needed to learn the law and also to win the trust of the architects of the arbitration clauses, who were a bunch of corporate lawyers who had no interest in telling us how they had engineered this, kind of incredible coup. So what the big challenge was learning the law almost better than they knew it, or as well as they knew it, to go to them and say, look, I understand the genius of what you did. I mean, regardless of, whether we think class actions are good or bad, and we can disagree on that, we can both agree that you've killed them. And by saying that to them and then actually walking through with these various lawyers how they did it, by saying, oh, so this is the legal argument that you engineered in this instance, and this is the one that you made to the appellate court in New York, and this is the one that you made to the appellate court in California. That began to help us because we were, I think, winning the respect of the people that had done this. Because just to say to them, look, I know what you did, and I think it's rather remarkable, was a powerful thing. And then I learned in the course of reporting that one of the kind of key players behind the scenes in this legal coup was John Roberts, who now we all know as the Supreme Court Justice. But when he was a private litigator, he represented Discover Bank in a case that the Supreme Court actually refused to take. But the basis of that case was arbitration should be allowed to ban class actions. And this was a very contentious idea. The Supreme Court didn't grant cert, so in very simple terms, they didn't agree to take the case. Fast forward, 8 years, Justice Roberts is no longer a private lawyer. He's a Supreme Court justice, and suddenly the Supreme Court agrees to take a case involving the very same kind of issues that it had previously denied to take. So we knew he had made this legal petition on behalf of Discover to get the Supreme Court to take this case. And I went to talk to one of the lawyers who was an architect of the decision, and I asked him, you know, what do you make of John Roberts now being on the court? You know, it seems like it would be to your advantage, since he had written this brief in 2002 petitioning the Supreme Court to take the very same case that they ended up taking 8 years later. And I think the lawyer I was talking to was so shocked that we even knew about this that he was thrilled to talk about it. So he was like, oh, well, yeah, no, I mean, we thought that we had a really good shot of winning that Supreme Court case because I actually, you know, I helped John Roberts craft that brief, and then, you know, he helped us later on. And I mean, that was kind of a remarkable turn for us because it showed just how concerted this effort had been and how it had involved the highest levels of the Supreme Court. So that to me was one of the biggest challenges.
Okay. Michael.